advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or interact with the show by sending an email to ask@dewittlaw.com. That's ask@dewittlaw.com. Every Sunday morning, we'll be here 10 a.m. You'll learn how Florida's legal issues affect you. And your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions to discuss the latest legal issues affecting citizens of Central Florida. Mo, good morning.
Good morning. How are you doing this morning?
I'm good. It's Casey right here in for Jay, and now it seems like this is how the show's going to go for now, Mo.
That's what they tell me. I was going to say you are not Jay.
I'm not Jay.
Yeah, I was very confused. Didn't know what was going on. But we'll figure this out one way or another. But no, welcome to the show, Casey. And we've met before, and so happy to have you here. And jump right into some legal issues affecting the state.
Yeah, absolutely. The Disney versus DeSantis has been the topic of the headline all week long, and it continues to get more interesting as we look more into it. Mo, we started with him trying to absolve the agreement that they made in the first place that DeSantis thought would help out the Disney Reedy Creek District. Then he found out they made a deal that would extend their control over 30 years. So DeSantis decided to absolve that agreement as well, and then Disney decided to take matters into their own hands.
Yeah, so Disney's now filed a lawsuit against Governor DeSantis as well as some other high-ranking officials in the state of Florida. And, I think most people out there kind of know the history of what's going on here, but obviously Disney's prior CEO spoke out against, I think it was the Don't Say Gay bill is what they refer to. I know it has a real name, but that's kind of what everyone knows it by. And, basically said, hey, we're going to dissolve Reedy Creek. And so then Reedy Creek went in and put in some long-term land use contracts. Then the new board, which I think was called the Central Florida Tourism Oversight District, came in. At their first meeting, they didn't discover the new contracts. At the second meeting, they finally said, wait a second, what are these? Found them. I think everybody's basically admitted at this point that the notices for those meetings and the contracts were properly noticed. So it's not really a notice issue. Then after they discovered them, the state of Florida, again, the legislature passed some legislation basically eliminating those contracts. And that's where it really gets interesting, because the lawsuit that Disney has filed against the state, it's against Governor DeSantis, but really it's against the state of Florida, argues that the contracts clause protects its property rights. And so, the government can't pass laws typically, except for in very limited circumstances, that affect contracts or void contracts that were already in place. And, we actually talked about this, it might have been last year at this point, when the alimony bill was going through the legislature.
Right.
And if you recall, the alimony bill went through the legislature, it got passed, and ultimately Governor DeSantis vetoed it. And he vetoed it saying that he believed it would be unconstitutional. And while he didn't specifically say why, it was read into basically that the one provision in the alimony bill eliminated permanent alimony retroactively. And so what does that do? That retroactively infringes on contract rights, because if you have a marital settlement agreement where you've settled with your spouse and you guys have agreed to permanent alimony, the government, constitutionally speaking, can't come in and change that contract.
Right.
And so in that case, the governor ultimately vetoed that bill, saying he believed it to be unconstitutional. We think it was because of that provision. The letter that he wrote didn't specifically outline that. But that being said, that's essentially the same argument Disney's using here. They're saying, hey, under the contracts clause, you can't come back and unilaterally void a contract that was made by a private entity without our knowledge or without our consent, essentially. And so that violates the contracts clause of the Constitution. Now, they also argue that there is a unconstitutional takings. So takings is essentially when someone comes in and takes a property or your property rights. And that doesn't have to be the entire property. It can be part of the property, or property rights also go along with that. So, you've probably heard of eminent domain. That's a form of a taking, right? The government comes in, they take your property, but they have to pay you for it. So Disney's basically saying, hey, this is a taking. If you're going to take some of our contract rights here, you have to pay us money to do so. And there's, takings cases are actually pretty interesting because they kind of go all over the place. There's been cases where, cable companies want to run cables up the side of like a condominium building. And in certain jurisdictions, that was considered a taking because you were running the cable over other people's
Right.
property.
Or under,
So or under. So they can go kind of all different ways, basically. But that is one of their arguments as part of this lawsuit. And then finally, they're arguing that the state of Florida is infringed on their First Amendment rights. So the U.S. Supreme Court has held that corporations have freedom of speech. And so they're basically saying, look, you're retaliating against us for our freedom of speech as a corporation. We have the right to take a stance, to say what we want, and this is direct retaliation because of that. So, they're asking for, declaratory judgment that these bills that have essentially been passed are unconstitutional and asking for the state of Florida to be prohibited from taking this kind of action in the future. So it's a pretty interesting lawsuit from a legal perspective. I won't really get into the politics of it because everybody knows this is whether you're on one side or the other. Obviously, there's politics on both sides here, and both sides could be argued that they're politically driven. But just from a pure legal stance, all these arguments that Disney is making here are all constitutional arguments. So they're pretty interesting arguments. They've brought in some pretty big league attorneys. None of the attorneys who are behind this are from Florida. They have local counsel here in Florida who's bringing the lawsuit, but they're Washington D.C., New York City, California type lawyers who really put together some pretty thoughtful arguments. Whether they'll prevail or not is a different story. I'm not saying that they will prevail, but from a constitutional standpoint, they're basically making arguments that the state of Florida has violated Walt Disney World's constitutional rights as a corporation that owns property within the state of Florida. I think it'll be very interesting to see, where this goes and ultimately if they prevail or not. Now, the one thing that always kind of frustrates me is, obviously Disney's a billion-dollar corporation, I think. They have plenty of money to fight this.
Right.
On the other side, now the state of Florida, us as taxpayers, have to foot the legal bill to fight this. And so, at the end of the day, what are we really fighting about? Does this benefit the citizens of Central Florida in any way?
Right. It seems like they both tried to find a compromise with the district, which was also an interesting factor in all of this. And mentioning the fact that there are other self-governing districts in Florida, which is something I didn't know. I'd like to find out which one. I don't know if you know where those other self-governing districts are.
I don't offhand, but, I always kind of looked at, if you look at the history of Reedy Creek, basically, when Disney wanted to come to Florida, the state of Florida basically said, we don't have the money to build out the infrastructure for you to come here. Mm-hmm. And so they came up with this, Reedy Creek district where basically Disney paid for the infrastructure. And in exchange for that, I think the best way to describe it is it's almost like its own HOA, right? The reason we have so many HOAs in Florida is because the local governments don't want to have to maintain the common areas. Like in my neighborhood, because I don't have an HOA, the city comes in with their lawn crew and they have to trim everything and do all that. Well, the reason the HOAs become so popular is because the cities don't want to have to do that. They want to hand it off, basically, I know it's not really private, but to the private HOA, so to speak. So Reedy Creek is almost just a bigger version of that, right? So the state of Florida said, we can't build out this giant sewer system you guys want on the roadways and this and that. I mean, we were just orange groves back before Disney came to Central Florida. So they came up with this deal with the state, which is basically the Reedy Creek Improvement District. Mm-hmm. That's what it was designed to do. And I assume there must be some other ones in the state of Florida. I don't know where those are offhand. But essentially, it's really just a big HOA, essentially. It's kind of the way it's structured. Obviously, it's for a private corporation, so it's a little different than an HOA. Mm-hmm. But just for the listeners out there, I think that's kind of the best way that you can analogize it.
Yeah, that's a good way to determine it as far as how they've structured themselves. And I didn't know the fact that they didn't have enough money for them to build here for the state. That's why they decided to do their own. Obviously, this agreement happened at some point. Disney's been around for quite some time. The other interesting factor of all of this, and if you want to go into this, you can, because, again, I don't know what these other places have to abide by, which is what Governor DeSantis is saying and claiming, that he mentioned in Israel when he was talking about all the other theme parks in Florida. Because, yes, we know Disney's here. They are a very powerful force. But there's also SeaWorld. There's also Universal. There's FunSpot. Now there's iDrive at Icon Park. There's a lot of other entities that have the same, I guess, entertainment factor here in Orlando, but seem to be working under different circumstances. Can you kind of divulge into that as far as what is DeSantis getting at with saying that they are forced to do these things and Disney's not forced to do certain things?
Well, I think the first major difference is just the amount of land that Disney owns, right? So they're responsible for maintaining all of that land.
Hmm.
And so, yes, there are other theme parks, but part of the agreement that Disney came to with the state of Florida was this sort of self governance. And yes, the self governance goes to things like inspections and building permits, but it also goes to maintaining that property. And I'm curious to see what the acreage is on Disney. So Disney's 25,000 acres. Just looking it up here. Universal is 500 acres.
Big difference.
541 if we want to be, specific. So huge difference.
Yeah.
Huge difference. So, from the government's perspective, the state can't have it both ways, right? It's either one or the other.
Hmm.
Either they're a self-governing body where they're responsible for all their utilities, their inspections, their maintenance, they handle everything themselves and they pay for it, or it's all gone and the state has to pay for that.
Hmm.
And so that's the question that I have, as a taxpayer is, number one, why are we going to be volunteering to pay for
Right.
this?
Yeah.
Because, and nobody know this is all speculation, of course, but when this first started unraveling, a lot of people are saying it could double or triple our property taxes here in Central Florida. Well, if you live here, you certainly don't want that. And who knows if that's true or not, if that's just a scare tactic. But, it's basically one way or the other, right? There's kind of no middle ground. So, the governor's basically saying, hey, yeah, these other companies have to abide by this, but they're not it's just the land difference, really. They're not self-governing bodies because they don't have 25,000 acres to take care of. And, Disney maintains that property. They take care of that property. They provide the infrastructure for that property. They have their own fire departments on that property. At 541 acres, Universal doesn't have the same level of responsibility. Also, they came in later. I mean, just being realistic,
Right. Before those contracts were made, yeah.
And the area had money at that point, right? Disney came in, they brought the tourism here. There is now money here where the state and the city and the counties had the ability to kind of build out some of this infrastructure. When Disney came in, they didn't have the ability to do that. And like I bring it back to the HOA again, that's the same thing with the HOA. Once they build the neighborhood, the county doesn't want to pay to maintain it. So that's why they did it this way.
Yeah, absolutely. It's definitely going to be an interesting case. It's going to be interesting to see how it develops and how it panders on further. And there's obviously a lot of information to be discussed with it. I think the one thing about Disney that always peculiar, you mentioned self-governing power. They have to maintain all the land, is who controls the roadways? Because I've been to Disney several times. I'm always curious on who patrols that side of the highway. I'm former law enforcement. We'll get into that, I'm sure, at some point on your segments on your shows. But I'm always curious about that part with Disney. So you're listening to the DeWitt Law Review here on WDBO 107.3 FM and AM 580. We're going to answer all your questions that you sent to ask@dewittlaw.com coming up next here on WDBO. We'll be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk, talking about all of Florida's legal issues that affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions to discuss the latest legal issues affecting citizens of Central Florida. You can send an email if you want to ask a question at ask@dewittlaw.com, or you can call their office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. I'm Casey Wright here with the man himself, Mo DeWitt. And Mo, we were just talking about Disney's self-governing land, and we brought up the question of who actually patrols the area of Disney, because like you said, they have to maintain everything. They have to make sure everything is up to code, make sure everything is running smoothly, and they also need to make sure it's safe. So who is running the Disney-governed land based off of what you know?
So, I mean, I'm certainly no expert on the matter, but my understanding is that Disney has their own, fire department in Reedy Creek, but that Orange County Sheriff's Office is still kind of the law enforcement there. There's Disney security, of course, but Orange County Sheriff's Office, as far as I know, is still, the police force out there. Now, I know Orange County Sheriff's Office does contract out to Florida Highway Patrol if there's car accidents. Typically, within the county, Florida Highway Patrol is the one that responds. I never fully understood why that is. Maybe somebody out there can call in and tell us if they have some information on that. So maybe if you get an accident in the Reedy Creek area, maybe it's still Florida Highway Patrol that comes out rather than Orange County Sheriff's Office. But as far as I know, It's Orange County Sheriff's Office who is the sheriff out there.
And I could probably answer that. So FHP has contracts with most of the counties here in Central Florida. I know Volusia County is the same way.
Okay.
All their traffic accidents goes to FHP as well. And I can't answer on Seminole County, but I would assume it's all the same. And I think it's just essentially they're built for that. They're trained for highway and traffic accidents that happen within the area in unregistered county area. If you're in a city jurisdiction, you will have the city take care of the traffic crash. Let's say if there's a crash in Lake Mary Police Department's going to take care of that traffic crash. But
Gotcha.
if it's unrestricted county area that's set for a deputy sheriff, then it'll be FHP. Again, I don't know why, but that's just what it is.
Yeah, I mean, because on our end, when we get car accident cases, people are often frustrated because, and this is no offense to Florida Highway Patrol, but sometimes it takes them a very long time to get out there. I assume they're just understaffed, essentially, to handle this area of property and all the car accidents that occur around here. So a lot of times I hear it takes 4 or 6 hours for them to respond. I was actually talking to somebody yesterday, and they were complaining that it took so long for Florida Highway Patrol to get there. I said, well, how long did it take him? And she said like 2 hours and 45 minutes. I said, that's actually good. That's pretty good time compared to some of what I've heard. And again, I don't mean that to be disrespectful to Florida Highway Patrol, because I know they have a tough job to do. And I think it's really just a staffing issue, given how large, Central Florida is and how many people are here at this point. It just becomes very difficult to come up, to take care of all that. But I kind of wondered, from does Florida Highway Patrol get to then keep the money if they write a ticket as part of the accident? Is maybe that the deal? I never really knew what the purpose of that was, or if there was a purpose behind that, or maybe it's just easier than having the Orange County Sheriff's Office or Seminole County Sheriff's Office deal with it.
Yeah, I think it probably just comes with the training and staff and resources. But like you mentioned, I mean, FHP is definitely understaffed. I always like to tell people, hey, go on the interstate, drive 30 minutes, tell me how many you see. I mean, there could be days where you see none in a 30-minute, 30-mile span. So, definitely an understaffment on their part. We don't really know why they do it. Maybe there is a better answer out there. But we'll have your questions coming up next here on the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. I'm Casey Wright here with Mo DeWitt this morning. We will be right back. But first, news, weather, and traffic.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk, giving you legal advice. You can call DeWitt Law's office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. Or you can interact with the show this morning by sending an email to ask@dewittlaw.com. I'm Casey Wright here with the man himself, Mo DeWitt. And Mo, that's where we're going here. The questions on askdewittlaw.com. Let's start with the first one here. We are 73 and 74. We have a son with Asperger's who is 39 and lives at home. What steps do we need to take to protect him after we are gone financially?
So one thing that you could look at doing is establishing a special needs trust, which can provide for a disabled beneficiary and can preserve some Medicaid and supplementary security or SSI income, essentially, supplemental security income benefits. And it can also, if you do that, it can help, prevent you from losing those benefits because there are certain income restrictions and things like that. So, but whenever you do that, there's two very important things to remember. Number one, you really want to work with an attorney who specializes in this area, and that's not me. If you need somebody who does that, I can certainly get you with that person and put you in touch with that person, get you in the right hands. But they are very specialized, so you want to make sure that you're hiring somebody who knows what they're doing. The other thing that you want to give careful consideration to is that you have the right trustee for the trust, because the trustee is going to make a lot of important decisions, including investment decisions, making sure bills are getting paid, tax returns are being prepared. So they should have some knowledge of the not only the special needs trust and public benefits programs, but they should also kind of know the eligibility, make sure they're not eliminating any eligibility from any governmental programs, as well as just have a good financial knowledge as well. So that's the one thing I would probably recommend looking at for somebody in that situation. But again, you definitely want to speak to somebody who's more specialized in that area. And if you give the office a call, we can certainly put you in contact with somebody who does that, because again, it is a very specialized field.
Yeah, and a very important circumstance in someone's life, I guess you could say, when you have that situation. All right, next question. I am in the process of divorce. It's not official yet, but the husband, or my husband rather, is willing to relinquish all rights to the house. What do I need to do to make it legal or official?
Well, first thing is there's never an agreement unless it's in writing, right? So, I once had a case one time where the parties, they brought to court. I mean, it was almost a napkin. It was kind of a piece of paper, but not a real one, where they had like handwritten how they were each gonna split the bills after they split up, and the judge just basically laughed at him. It was like, that's not an agreement.
No.
So the first thing is get it in writing. So what you want to do is, if there are other issues in the divorce that still need to be resolved, but you resolve the house issue, you can do what we call a partial marital settlement agreement, which is exactly what it sounds like. It's just a settlement agreement of a partial matter of the divorce. The entire divorce isn't done yet, but you've resolved this one matter. So you want to draft that up. You want to have both parties sign it. You also want it to be notarized because you're dealing with real property here. So if he's willing to convey you the home, you put in what the terms are. Of course, I would recommend having an attorney draft it, but you kind of get the idea there. Once that is done, you can then file that with the court in the divorce file, and you're going to want the judge to enter an order adopting and ratifying that agreement, which basically means you're turning what was a contract, the marital settlement agreement's a contract, you're now turning it into a court order by having a judge adopt it and ratify it. Now, one thing to consider, though, I'm kind of backing up a little bit here, is, he's agreeing to convey you the house, but is there a mortgage on the home? So how are you going to deal with the mortgage? Are you planning on refinancing the home? Is he going to agree to stay on the mortgage for a certain period of time? You want to kind of walk through how you're going to deal with that. If the mortgage is only in this party's name, that makes it pretty easy. They just deed it over as part of this agreement, and then she continues to pay for the mortgage. If it's in both parties' names, then they may have to refinance the home to take the other party off of the mortgage. Just typically, if you're deeding away the asset, you don't want to be on the liability that's associated with the asset.
Right.
And I've seen a lot of people who do a divorce on their own or online or whatever it may be get into trouble with that. There was a person who contacted us a little while ago who did that exact thing. She deeded over the home to the husband, but she was still on the mortgage. Well, a couple years later, he stopped paying the mortgage. Her credit's being hurt, and she doesn't have any legal rights to force him to do anything because the agreement didn't give her any legal rights. She signed away all rights to it. So you want to be very careful of a situation like that. You want to make sure you don't put yourself into that situation. I've had cases before where you put in a provision if the mortgage is ever 30 days late, then the property is automatically to be listed and sold. I still don't recommend that, but at least that's some sort of protection there. Typically, if your name is on the mortgage and you're going to sign over the deed to the other party, you want a limited amount of time for them to refinance. So maybe you give them 3 months, 6 months, something reasonable to refinance the home. If they can't refinance within that period of time, then you have an agreed upon real estate agent where it's listed with that real estate agent. at either whatever price they recommend, or you guys agree on a price. Sometimes we'll do a side agreement that's not to be filed with the court, where then if the home doesn't sell right away, which we haven't had that issue in a while, but market's slowing down, so we might start having it again. Or if the home doesn't sell right away, then there's automatic deductions. Maybe it reduces at 2% every 30 days. Now we do that as a side agreement because we don't want that in the court file where a potential buyer could see that and then go, oh wait, if I just wait a little while, the price will continue to come down. So that's why we do it as a side agreement. And again, these are all oversimplifications, but they're things that you want to be aware of if you're going through this process, because there are a lot of everything's great in a divorce when everybody's getting along, right? So people call me all the time, oh yeah, we agree upon everything. It should be super easy. I just want to be fair. And I've said this before on the show, what you think is fair and what your spouse thinks is fair are two different things a lot of times.
Right.
And so that's where people get into trouble is, you think you're on the same page and you're just not. Or, you do this agreement and say, oh, we'll kind of work it out later. And then something happens, parties get remarried. The new spouse doesn't like the old spouse.
Right, you can't predict that stuff.
No, you can't. I mean, so, as attorneys, we're always kind of thought to think in a worst case scenario analysis, which makes us very paranoid people, I think. But, when you're going into this, that's kind of how you have to think is, okay, if everything goes wrong, does this protect me? And how does it protect me? And what are my rights if everything goes wrong? Because the last thing you want to do is you deed over the house, you're still on the mortgage, they stop paying the mortgage. Now your credit's ruined. You can't buy a house. You can't get a credit card. You can't get a car loan. And then, you thought everything was great, but you didn't protect yourself. And so that's really what you want to be cautious of here. But anyways, back to her question, after you sign that marital settlement agreement, get the judge to adopt it, then you do a quick claim deed where the husband would sign over the property to this individual. And then you basically take full control of the home from there.
And if they want more information on this, they probably could go get your book, DeWitt's Divorce Guide.
Oh yeah, we have a whole section in the divorce guide, DeWitt's Guide to Divorce. You can get it at DeWittDivorce.com. You can download a copy there. It's also on Audible, and I think you can buy it on Amazon. I'm pretty sure it's in print there. It's also on Spotify if you want to listen to it, the audio book version of it. But yeah, we discuss all of that in there. Kind of things I've seen over the years as far as what's gone wrong in somebody's divorce and how you should, kind of approach that and handle it properly. So if you're going through a divorce or somebody who's going through a divorce, certainly download it, read it. I think it's good information, but I also wrote it. So
and it has to be, because you are giving all this information to this past question, and then you have a whole section, not just the book itself, a whole section just divided to what we just spoke about. It makes me curious, Mo, on what percentage would you say divorces are mostly personal items that people own, houses, cars, boats? Is that sort of taking the toll on a divorce case, or is there another aspect that sort of beats the punch to what people own and what people don't?
Well, I think the hardest part about divorce is just the emotional aspect to it, right? So, as lawyers, as people in the legal system, even the way judges approach it, I think, when you look at a divorce from a legal perspective, with the exception of children, it's really just splitting up assets. It's really just a financial transaction, right? So, when you come into a divorce, though, as the individual, as the husband or the wife, as the person who's getting a divorce, it's very difficult to look at it as a financial transaction, because there's a lot of emotions to it. You've built a life, you've built a family, you've built assets, and now you're having to divide those up. So, kind of helping people realize, look, there's life after divorce. This is kind of a blip on the radar that we need to get you through, and we need to set you up for success in the future, whether that's with your assets or with your children. We need something that works for you, and trying to get them past that emotional stage of being angry or wanting revenge, because you just don't want to live in the court system for 5 or 10 years. Right. You don't want to live in the court system for the entirety of while your kids are minor children. I mean, you're kind of missing out on a lot of that when you're constantly fighting in court over every little thing. So I think that's the hardest part about divorces. I've had, divorces that involve, tens of millions of dollars that have been easier than divorces that involve hundreds of dollars, because it's all about the emotion and kind of helping guide people through that process.
Yeah, especially at that point. So it kind of, I guess, humbles you when you go home and you have to deal with stuff like that. You understand what people are going through, and the respect you probably give to your clients is an utmost important factor of what you do. And again, folks, you can go, it's DeWitt's Divorce Guidebook. You can go get that for you if you have any questions on that, or if you have questions, 1-800-DeWitt-LAW. Please call them for your legal advice. They can help you out, get through these tough times. We have time for one more question, Mo, so let's get into our last question here in this segment. My ex is trying to move out of state with her new husband, and they are trying to move to Illinois. We do not have a parenting plan in set. I see my son 3 nights a week. She gets 4 nights a week. I pay my child support religiously, pick him up every week. Does she have a chance to do this? And what would you change, or what would you charge to take a case like this? And he said, thank you for your time. So in a situation like this where you have a parent trying to leave with the children away, no parenting plan in place, what sort of action can he take here?
So I'd be curious why you do have a parenting plan. Sorry, I misheard. I thought you said you do not have a parenting plan. So they do have a parenting plan. So in the state of Florida, this is what we would call a relocation case. So basically the wife here, or the ex, is trying to move out of the state of Florida with their new husband. Something that we see fairly frequently. But in a relocation case, you essentially have to prove, I think it's 11 factors. It's either 11 or 13. I always forget. But basically those factors are whether the relocation would be in the best interest of the child. And so it's a pretty difficult standard, in my opinion. You typically have to show that there's some sort of unique opportunity in this new state, in Illinois, that would really benefit the kids somehow. Typically the benefit is financial. One of the parents can make a lot more money there. One of the cases, and one of the few cases that's been granted that relocation case, was a case I handled where our client had a unique opportunity in the media that was really only available in New York City. So they didn't have this type of, I'm trying to keep it vague so the person couldn't be identified, obviously, but they didn't have these type of media outlets here in Central Florida. So they asked to relocate to New York because the person had a contract with this media outlet there. It's the only place that they were headquartered, so on and so forth. And so in that case, it offered a significant financial incentive to the parent, which ultimately would benefit the child, the court found. So they allowed the relocation there. But usually it has to be something unique like that. It can't just be that the old spouse is following her new spouse because they want to move to Illinois. So you're going to go through things like showing what the ties to the community here are. How long have you lived in Central Florida? Do you have parents, relatives, a support system in Central Florida? What kind of job do you have here? If you're an Uber Eats driver, for example, well, you could do that anywhere. So that's going to go against you being able to stay here. It's probably going to allow the relocation. But if your job does not allow you to work from anywhere, then the court would probably rule against the relocation. So they're going to look at all those kinds of factors when determining, is relocation in the best interest of the child or the children. But ultimately, it has to typically offer some sort of benefit. And the benefit could be, outside the financial realm. Maybe, the ex here wants to move to Illinois because her entire family is there and she has no family here. And maybe you only moved here, a month ago or 3 months ago. We've had cases before where, the family's kind of a nomad and moves around the country. Right. And they just happened to be in Florida when they got the divorce. Right. So then the court's more likely to grant them that divorce, or grant the relocation, allow the parties to move. So those are the kinds of things that the court's going to be looking at when determining if they're going to allow relocation.
And we'll have more from Mo DeWitt coming up here after the break. You're listening to the DeWitt Law Show here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. We'll be right back with more of your questions.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was it was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. If they're mailing out a letter, anything, I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's News and Talk, helping you out with all your legal advice that you need with the man himself, Mo DeWitt. You can contact their office anytime at 1-800-DeWitt-LAW. That is 1-800-DeWitt-LAW. Or you can send us an email at ask@DeWittLaw.com. That is ask, A-S-K, @DeWittLaw.com. And we'll be able to answer any of your questions you may have on the show here, which, Mo, I think we do have a question here that should take us out for the rest of this show, and here it is. I was served paperwork for an injunction from my ex-girlfriend, who I have a 5-month-old baby. And on top of it, I am a community control probation. He's on community control probation. The injunction was filed right around the same time, within days of her possibly finding out that I'm now dating somebody else. Everything she's alleging is either false or blown out of context. Any of the allegations she's putting against me are from months and months ago, and all of a sudden, now she wants to do this. So my question is, what should I do as far as going to court for this? He's not sure if it'll violate his probation. So what should he do next?
So the first thing he wants to do is hire an attorney. So while injunctions are civil cases, if you testify in the injunction, that could be used against you in a criminal case. So that's why in a situation where you're on probation especially, you want to be very careful about what's said in this injunction hearing to make sure you're not violating your probation and that you're not admitting to any crime, certainly. So that's paramount. Hire an attorney for that reason alone. Now, a lot of times with injunction cases, because they are civil, people think, oh, I can just handle this on my own. But, injunction cases can be very detrimental to your career, to your life, to seeing your children. So you want to make sure you have proper representation, because there are a lot of legal intricacies when it comes to injunctions. And injunctions just really a restraining order. That's kind of what we're referring to here. Unfortunately, this scenario is probably more common than you would expect. I have a good friend who this just happened to a few months ago, actually, where he broke up with his girlfriend, got a new girlfriend, and the day that he the old girlfriend found out about the new girlfriend, guess what she did? Well, she went down to the police station and alleged that he had beaten her, and and now he's going through this whole legal process as well. And so you want to contact an attorney who can first of all, gather all the evidence if there is evidence, because the tough part about these cases a lot of times, it's the he said, she said scenario, right? So you have to be careful about how you disprove the other side's allegations without testifying or potentially incriminating yourself, especially if you're on probation, because as we know, probation's a little bit different where, you can violate probation for other things that may not normally lead you to arrest, if that makes sense. Depending on the type of probation you're on, you may not be allowed to drink alcohol, for instance. And if she testifies that you drink alcohol and you say, yeah, well, I had a beer or two, well, you've potentially just violated your probation. So that's why you want to be very careful about that. But if there was any witnesses to the events, you certainly want to gather those. If there's any video evidence, that can be very helpful in injunctions. But the other thing is to look at what the allegations in the injunction is very carefully, because you can't just file an injunction and say, oh, 5 years ago, he shoved me. Because the whole purpose of an injunction is to protect someone who has a reasonable fear that they're in great bodily harm or imminent death. Mm-hmm. So it's not to be used as a retaliatory tactic. It's used for protection. It's an injunction for protection against domestic violence. So typically, if that allegation didn't occur within the immediate future, usually the court is not allowed to consider that as part of the injunction. Now, if there was a threat of violence or an allegation of violence that was in the immediate future, then they can go back and look at the history of violence as well. But you can't just say, oh, 3 years ago, 5 years ago, this happened. Typically, that's kind of outside the time frame that's permitted.
Yeah, and you have to really look at also, too, when handling a domestic violence situation, the time frame is number one important. And then, two, the physical evidence and what they have to pertain. If there's nothing there, if there's nothing to say, if they're just coming out making, uttering statements, there's really no backing. So
yeah, but from the injunction standpoint, the judge has a tough job, because no judge ever wants to be the one on the news where they denied the injunction and then the person went and killed the other person, right? So, I think the judges are always very careful when they're analyzing an injunction case. At least I would be if I was in the judge's shoes. I always try to, as an attorney, I think it's good to try to put yourself in the judge's shoes, because I think you want to try to see both sides of what the arguments are and kind of the balance of the powers there. So, on the one side, the judge, certainly doesn't want to put somebody in that situation. On the other side, they don't want to lock themselves, lock a parent away from their children, lock them out of their home, or grant an injunction when there's no basis to do so. So, injunction hearings are quick. They're typically half hour to a couple hours. It's like a mini trial, but they're kind of jam-packed with evidence, and they're going to be very quickly. And that's why I really encourage anybody, and it's an unfortunate situation. It's a terrible situation. And I always advise my clients who are going through a divorce or thinking about going through a divorce, if you ever think those allegations are going to be made, just move out of the house. It's not worth the headache. Get yourself set up somewhere else. Stay safe. Don't. On both sides. If you think you may be the victim of it, get out of there. If you think there may be false allegations, get out of there. You don't want to deal with it on either side. But if you do find yourself in the situation where you're being served with a injunction, or you need to serve an injunction on either side, I really recommend having good legal representation on your side to properly present your case.
Well, thank you for all your insight today. That's all we have time for, folks. You've been listening to the DeWitt Law Review here on WDBO 107.3 FM and AM 580, Orlando's news.